Ever wondered what powers the law enforcement has under the Terrorism Prevention and Investigation Measures Act? Let's delve into it. This act, often shortened to TPIM Act, is a key piece of legislation in the United Kingdom's fight against terrorism. It's designed to prevent and investigate acts of terrorism and to keep the public safe from potential threats. With powers ranging from issuing notices to conducting searches, this act plays a critical role in national security. It's essential to understand that these powers are not used lightly, but are reserved for situations where there's a genuine risk of terrorist activity. The Act provides a framework that balances the need for security with respect for individual rights. Now that we have a basic understanding of the Act, we're ready to dissect its powers and suspected possessions. Paragraph 2, 18A of the Act is particularly intriguing. What does it entail? Well, let's delve into this. The powers under this paragraph do not necessitate a constable to suspect individuals of contravening terrorism prevention and investigation measures, or TPIM, or suspected terrorism, prevention and investigation measures, or STPIM, notice measures. Nor is there a need for suspicion about the possession of anything that could potentially be a threat or cause harm. This power allows for a search to be carried out within 28 days of the warrant issue, and it should be at a reasonable hour, unless conducting the search at such a time would frustrate its purpose. In addition, powers under Schedule 5 of the Terrorism Prevention and Investigation Measures Act of 2011 and Schedule 11 of the National Security Act of 2023 enable a constable to conduct a search for specific purposes related to a TPIM or STPIM notice. If any evidence is found, it may be seized and retained, provided there are reasonable grounds for suspicion. Moreover, the powers to search premises also authorize the search of a person not under arrest found on the premises during the search. However, before the power under Section 139B of the Criminal Justice Act of 1988 can be exercised, the constable must have reasonable grounds to suspect an offence under Section 139A or 139AA of the same Act. It's important to note that the selection and treatment of those searched under these powers should be based on objective factors connected with the search of the premises, not on personal prejudice. So, while paragraph 2, 18A certainly gives law enforcement a wide scope of action, it is not without its limitations. These powers must always be exercised responsibly and within the bounds of the law. With paragraph 2, 18A, law enforcement has a wide scope of action, but it's not unlimited. The powers are specific, and their use must be justifiable, respectful of individual rights, and devoid of any form of prejudice or bias. Let's now turn our attention to the power to search under the Act. How does it work? There are specific conditions under which a search can be conducted. For instance, a search under this power must be executed within 28 days of the warrant issue and at a reasonable hour, unless it would frustrate the search's purposes. This ensures that the search is timely and respects the individual's privacy to a reasonable extent. Moving on to the powers under Schedule 5 and Schedule 11, these allow a constable to conduct a search for specific purposes related to a TPIM or STPIM notice. This means that the search is not arbitrary, but is tied to a specific purpose, aimed at preventing or investigating potential threats. If during the search, any evidence is found, it may be seized and retained if there are reasonable grounds for suspicion. This could include anything that is directly related to the notice, or could potentially harm or threaten the individual or others. Interestingly, these powers to search premises also authorize the search of a person not under arrest found on the premises during the search. This is a broad power, but again, it's not without its checks and balances. The power under Section 139B of the Criminal Justice Act 1988 can only be exercised if the constable has reasonable grounds to suspect an offence under Section 139A or 139AA of the same Act. At the heart of this power to search is the principle of objectivity. The selection and treatment of those searched under these powers should be based on objective factors connected with the search of the premises, not on personal prejudice. This is critical to ensuring fairness and preventing any potential abuse of power. In essence, the power to search is a crucial tool for law enforcement in the fight against terrorism and potential threats to national security. However, it's important to remember that this power comes with strict guidelines to prevent abuse and protect individual rights. The power to search is a critical tool for law enforcement. but it comes with strict guidelines to prevent abuse. Moving on, let's look at authorized searches under the Public Order Act, 2023. What does it say? The Act outlines specific conditions under which a stop and search can be authorized. An officer, at the rank of inspector or above, can grant such an authorization if they believe individuals are carrying prohibited objects or committing protest-related offenses. These offenses can range from willful obstruction to interference with key national infrastructure. This authorization isn't given lightly. The officer must specify the grounds for the search, the locality, and the period of time it covers. This period shouldn't exceed 24 hours. Once granted, the authorization must be communicated to an officer of or above the rank of superintendent. But that's not all. The Act also stipulates that the selection of persons and vehicles to be stopped and searched should reflect an objective assessment of the activity in the locality or the items in question. This means that prejudice or bias has no place in these operations. Those who are stopped and searched under Section 11 of the Act have rights too. They are entitled to a written statement within 12 months of the search. This statement should detail why and how the search was conducted. Moreover, any decision to give an authorization under the Act must be communicated to the public as soon as possible. This is crucial for maintaining transparency and fostering trust between the public and law enforcement. Finally, and perhaps most importantly, officers using stop and search powers during a protest must act compatibly with the rights to freedom of expression and assembly. These rights, protected under Articles 10 and 11 of the European Convention on Human Rights, remain fundamental even in the context of a public order operation. While these powers provide law enforcement the means to maintain public order, they must also respect fundamental human rights. Now that we know when and why searches are conducted, let's look at how they are conducted. The guidelines for police stop and searches emphasize the importance of courtesy, consideration, and respect. Officers are expected to treat all individuals with dignity, irrespective of the circumstances leading to the search. Cooperation is sought from the person being searched, and even if the person initially objects, officers are encouraged to use their communication skills to diffuse any tension. A forcible search is considered a last resort and may only be carried out if the person is unwilling to cooperate. The duration of detention during a stop and search operation should be reasonable and kept to a bare minimum. The goal is to ensure that the person's rights are not infringed upon more than necessary for the purpose of the search. Officers must also take care to respect the person's privacy during the search. The removal of clothing is limited to outer garments, and searches involving intimate parts must be done out of public view to uphold the person's dignity. Now, before a search is conducted, there are certain steps that must be taken. Officers are required to present their warrant card, which serves as an identification and authority symbol. They must also inform the person about their detention and the reason for it. The officer should explain the object of the search, that is, what they are looking for, and provide a copy of the search record after the search. This provides a documented proof of the search and serves as a safeguard against potential complaints or legal issues. It's also worth noting that stops and searches under certain powers may only be conducted by a constable. This is to ensure that these powers are not misused and that the person carrying out the search has received the necessary training and understands the legal implications of their actions. The conduct of searches is as important as the power to search itself, as it directly impacts the public's trust in law enforcement. We've covered a lot of ground today. Let's summarize what we've learned. The Terrorism Prevention and Investigation Measures Act, along with the Public Order Act, endows our constables with certain powers. These include the ability to search without suspicion of contravention, provided the search is conducted within 28 days of the warrant issue and at a reasonable hour. They can also seize any evidence found during the search if there are reasonable grounds for suspicion. Furthermore, the Act allows constables to search premises and any person found therein, even if they're not under arrest. However, before exercising these powers, the constable must have reasonable grounds to suspect an offence. Selection for a search should be objective, based on factors related to the premises, and not on personal prejudice. Understanding these powers is a crucial step towards ensuring accountability in law enforcement. It's been a pleasure sharing this knowledge with you. Remember, knowledge is power. Don't forget to like, share, and subscribe to Legal Lens for more insights into the law.